Be ready? Start. The aforesaid judgment dated 4/9/2015 rendered by Honorable Single Judge in the case of Mahavir Singh within bracket Supra was challenged by the State of UP by filing Special Appeal Defective number 884 of 2015 and the Division Bench of this court by means of its judgment and order dated 12/1/2016 while setting aside the judgment and order dated 4/9/2015 passed by the Honorable Single Judge has observed that mere recommendation made in the said case by the Superintendent of Police for giving out of turn promotion did not confer any feasible or vested right of promotion. Stop. The division bench further observed that once the government order dated 7/6/2014 had taken effect, which has the effect of residing the office memorandum dated 3/2/1994, any promotion which is required to be made would necessarily have to be governed by the statutory rules which hold the field. Stop. The division bench thus held that a conscious policy decision has been taken by the state government based on the exigencies of the service and in terms of the government order dated 7/6/2014, the office memorandum dated 3/2/1994 would stand resided and that the scheme of out-of-turn appointments would stand substituted by monetary compensation. Stop. It is thus in the background of the aforesaid facts that the special appeal was allowed and the judgment rendered by Honorable Single Judge in the case of Mahavir Singh within bracket Supra was set aside. Stop. Stanza. So far as the law laid down by the division bench in the aforesaid special appeal is concerned, there cannot be any quarrel. Stop. However, what is noticeable here is that the facts of the present case and the facts of the cases which were subject matter of the decision by the division bench in the special appeal defective number 884 of 2015 are distinguishable. Stop. The distinction between the facts of the present case and the facts which were under consideration before the division bench in the special appeal lie in relation to the date on which right of consideration for grant of out-of-turn promotion crystallized in favor of the petitioner in this writ petition and the persons who were seeking out of turn promotion in the case of Mahavir Singh within bracket Supra. Stop. There is no dispute that all the matters which were decided by Honorable Single Judge by means of judgment and order dated 4/9/2015, though recommendations had been made for grant of out-of-turn promotion prior to issuance of the government order dated 7/6/2014 and the incidents on the basis of which such recommendations were made had occurred prior to the side date, that is prior to issuance of government order dated 7/6/2014. However, in none of the said cases the matter was finally decided by the authorities in terms of the government order dated 3/2/1994. Stop. To the contrary, in the instant case, the decision was also taken for not granting out of turn promotion to the petitioner on 5/3/2013, which became subject matter of challenge before the UP Public Service Tribunal in the claim petition filed by the petitioner. Stop. Stanza. Thus, this court, while examining the matter, is called upon to see the legality or otherwise of the decision taken by the respondents for not granting out of turn promotion to the petitioner, and such decision in this case was taken prior to issuance of the government order dated 7/6/2014. Stop. Mere recommendation may not confer any feasible right or vested right to seek out of turn promotion. However, the fact remains that the case of the petitioner was already rejected on 5/3/2013 prior to promulgation of the new policy by the state government by notifying government order on 7/6/2014 stop. The tribunal, while examining the validity of the rejection order dated 5/3/2013, has come to the conclusion that the case of the petitioner for grant of out-of-term promotion was rejected unlawfully, and it is in this background that the tribunal had directed the authorities concerned to reconsider the case of the petitioner for grant of out-of-term promotion stop stanza. Having noticed the salient fact on which there is not much dispute, this court is firstly constrained to observe that there is no material or evidence to indicate what steps the corporation took between 30 April 1996 to 3 February 1998 stop. There is not one shred of evidence to indicate as to whether any notice was issued to the petitioner during this period to participate in the disciplinary proceedings stop. As noticed above, although the order dated 24 April 1998 asserts that various dates had been fixed by the inquiry officer appointed on 17 February 1997, no such notice has been placed on the record, nor have details of any such notice been alluded to or disclosed in the affidavit filed in these proceedings on behalf of the corporation stop. Even the order sheet which stands appended along with the counter affidavit of the corporation refers to dates which were fixed in 1996 stop. On the above state of the record, the submission of the learned counsel for the petitioner that the disciplinary proceedings were revived only in 1998 after a long spell of unexplained silence and inaction appears to have forced stop. On 17 February 1998, the corporation, although being fully aware of the pendency of the disciplinary proceedings, proceeded to pass an order holding that the petitioner would be treated to have retired from service with effect from 31 January 1998 stop. If the petitioner was permitted to retire with effect from 31 January 1998, this court fails to comprehend what authority inherent in the corporation to proceed with or continue the disciplinary proceedings or to inflict any punishment upon the petitioner stop stanza. As noted above, no statutory provision, rule or regulation prevalent in the corporation was referred to or relied upon to sustain the continuance of the disciplinary proceedings after the retirement of the petitioner on 31 January 1998 stop. Once the petitioner had retired from service, no authority vested in the corporation to continue with the disciplinary proceedings which had been initiated against the petitioner stop. Retirement of an employee cuts the cord which connects the two entities and severs all relationship of master and servant or employer and employee stop. The retirement of an employee brings the curtain down upon the relationship of employer and employee stop. Once this event occurs, no further jurisdiction or authority vests in the employer to inflict any punishment upon the employee thereafter stop. Even otherwise, the following facts also need to be highlighted stop. Admittedly, the inquiry report was submitted on 19 February 1998 stop. A reading of the said report which stands appended as Annexure 14 clearly shows that the inquiry officer has not recorded his satisfaction in respect of the guilt of the petitioner on the basis of any material or evidence on record stop. The only conclusion recorded by the inquiry officer is that since the petitioner did not cooperate with the disciplinary proceedings and that from his conduct it is clear that he does not want the proceedings to be concluded, he had no option but to record a finding that the charges stand proved substantial. It is tried law that even if disciplinary proceedings are continued and culminate ultimately ex parte, the inquiry officer is under a positive obligation to record his satisfaction with others' stop over.